Okay, how copy over?
All right, Your Honor, we're on you.
Good morning, ladies and gentlemen. Welcome back to Bexar County Court of Law number 6, the Bexar County Veterans Treatment Court. I'm Judge Wayne Christian, representing the state in all matters will be Assistant Criminal District Attorney Arthur Reed and Karina Sanchez. Representing the Bexar County CSCD will be Ms. Susan Gross. Ms. Gross, I will swear you at this time. Please raise your right hand. Do you swear the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you. Cases I have set for hearing today are cause number 666-911, State of Texas versus Vicky Sanchez, represented by Jennifer Barres-Solis. Ms. Barres-Solis, are you ready to proceed?
Yes, good morning, Your Honor. We're ready.
Thank you. I have motion to revoke probations, cause 641-925 and 642-678, State of Texas versus Jose Longoria, represented by Mr. Todd Coronado. Mr. Coronado, are you ready to proceed?
Ready, Your Honor.
Thank you. Cause number 647-640, State of Texas versus Jonathan Chavez, represented by Barry Hitchings. Mr. Hitchings, are you ready to proceed? Barry with us?
He's still in a breakout room doing the paperwork.
All good. Cause number 643-267, State of Texas versus Tony Jacks, represented by Joseph Stateson. Mr. Stateson, are you ready to proceed?
He is also in a breakout room with his client.
Okay. Cause number 656-350, State of Texas versus Ryan Buntello, represented by Teresa Garcia, and also 684-741, excuse me, with Teresa Garcia. Ms. Garcia, are you ready to proceed?
Judge, I'm ready to proceed on the motion to revoke, which is 656-350.
I'm sorry, I missed that. You got a motion to do what with it? I'm sorry?
Yes, it's a motion to revoke. He's got a new number one, or he's got a new case, but we're not ready to proceed on that one yet because we wanted to ask you if we could do it all today or not.
We'll get back to you on that. Probably not, but I'll be happy to chat with you about it. Let's wait till the state gets all back in here. Cause number 671-400, State of Texas versus Tanisha Martin.
Good morning, Your Honor. My client is with me in her office, and her father is with her, who would also like to give testimony to the court. You have a letter that I have emailed the court, handwritten by her father. We are ready to proceed.
Thank you, sir. And I have a copy of the letter. I've not had a chance to read it. We will do that at the appropriate time, and you're certainly welcome to call anybody you wish. Thank you. Cause number 634-471, State of Texas versus Stephanie Torres, represented by Trey Porter. Mr. Porter, are you ready to proceed?
Good morning, Judge. We're ready to proceed. We provided the court with a packet for review. We provided the same to the state. We're ready when you're ready, sir.
Perfect. Thank you. Cause number 655-767, State of Texas versus Jacob Juarez, represented by Zally Gonzalez. Ms. Gonzalez, are you ready to proceed?
Yes, Judge, we are ready to proceed.
Thank you. Cause 604838, State of Texas versus Rudy Castillo, represented by Brett De La Paz. Mr. De La Paz, are you ready to proceed?
Yes, Your Honor. Good morning.
Thank you. And Pat, let's see. Ready on the plea. We're ready on Mr. Longoria. I don't have the waivers on Mr. Chavez yet.
No, Your Honor, they have not signed that paperwork yet.
Let me go through this and then you tell me if I'm supposed to have any of these. That's what I'm going to. So I have Longoria. I do not have Chavez. I do not have Jacks. I do not have Buntello.
Buntello has been sent to you, Your Honor.
All right.
You just need to sign it and then.
I have Martin. I have Torres. I do not have Juarez. And I have Castillo.
I believe I had sent you Juarez. I'll double check, Your Honor.
And are there two cases on Buntello?
Yes, Your Honor. There's an MTR and then there is a new case.
I got you. All right. Well, only one MTR though, correct?
Yes, Your Honor.
Correct.
Good. All right. If Ms. Barres-Solis is ready and Ms. Sanchez is ready, let's do the plea. This is cause number 666-911, State of Texas versus Vicky C. Sanchez. Ms. Sanchez, the first document I'm looking at is entitled entitled Defendant's Consent to Plea by Video Conference, signed by both Ms. Sanchez and Ms. Barres-Solis. In fact, Ms. Sanchez, is this your signature on this document, ma'am?
Yes.
Thank you. And Ms. Barres-Solis, as attorney for Ms. Sanchez, is this also your signature on this document?
Yes, Your Honor.
Thank you. Ms. Sanchez, the next document I have for you is entitled Defendant's Waiver of Constitutional Rights and Court's Admonitions. It purports to have your signature on the back. effectively waiving certain constitutional rights you must waive in order to enter a plea before this court. In fact, ma'am, is this your signature on this document also?
Yes.
Thank you. By signing this document, are you telling me that you've had enough time to either read this document or have it read to you in its entirety? If you had any questions about what was on this document, those questions were answered to your satisfaction by your attorney. So that in signing this document, you're telling me that you agree with and understand everything on this document. Is that correct, ma'am?
Yes, sir.
Thank you. Ms. Barrera-Solis, have you had enough time to go over this case with Ms. Sanchez, and in your opinion, is she mentally competent?
Yes, Your Honor.
Ms. Sanchez, are you a United States citizen, ma'am?
Yes, sir.
Thank you. And Ms. Barrera-Solis, has the state fully complied with discovery for you on this case?
Yes, Your Honor.
Thank you. State, are there any motions on this case?
No, Your Honor.
And this case is starting out as the DWI first, is that correct?
Yes, Your Honor.
All right. Ms. Sanchez, in cause 666-911 to the charge of driving while intoxicated, first offense, how do you plead, ma'am?
Guilty.
Is there an agreement for Ms. Sanchez?
Yes, Your Honor.
Yes.
The agreement is $500 fine, court costs, 180 days in Bexar County Jail, over 12 probated over 12 months, 48 hours community service, DWI education, DWI victim impact panel, CAT-SNP, Smart Start Mobile for half the term, and $60 to DPS for lab.
And Ms. Barrera-Solis, is that your understanding of the agreement?
Yes, Your Honor. I thought the Smart Start was for 3 months, but if that's statutory requirement.
My understanding is we always utilize Smart Start Mobile half the term. If they do well on it, we take it off after half the term. The term is 1 year, so it'll be 6 months on the Smart Start, unless y'all agree to something else.
I had thought it was for 3 months, but I'm not sure if that is the state's.
State, are you trying to cheat a nice defense counsel again?
Not this time, Your Honor. The Smart Start Mobile is for half the term, so it'll be 6 months.
Okay.
Is that
That's fine,
acceptable
Your
for the
Honor.
defense? All right. Ms. Sanchez, in cause 666-911, the court accepts your plea of guilty to the charge of driving while intoxicated. First offense, I find you guilty. I said 6 months in the Bexar County Jail, probated for 1 year, a $500 fine plus court costs, 48 hours community service, DWI education, DWI victim impact panel, Community Alliance for Traffic Safety New Intervention Program or equivalent outpatient drug, Smart Start Mobile home interlock at 4 blows a day for half the term, which is 6 months, $60 reimbursement to the Texas Department of Public Safety. And y'all don't live in Bexar County. Where do y'all live?
In Jim Wells County, so would ask the court to allow her probation to be transferred here.
And I'm sorry, what is your county name again?
Jim Wells?
Jim Wells, thank you.
Yes, Your Honor.
And Susan, we can do that?
As long as the probation case is a year, or you can maintain jurisdiction and she can report here via Zoom.
No, I want her to report down there. It'll be more convenient for her.
Right.
All right, is that okay with you, Ms. Barrera-Solis?
Yes, Your Honor.
Susan, do you have any information for Ms. Sanchez?
Yes, Ms. Sanchez, the probation department will reach out to you either via email or text, probably within the next 48 hours. However, if you have not heard from them by next Tuesday morning at 10 o'clock, you need to call this phone number, 210-335-7446. Advise them that you were placed on probation and you need an orientation date. Okay, they'll do your orientation via Zoom. It's your responsibility to make sure that you get those conditions signed. If you have any issues, contact your attorney. She can reach out either to myself or to the judge, and we'll try to assist you with whatever you need. Any questions?
No.
All right, good luck to you, ma'am.
Thank you.
Thank you.
Okay, thank you, Ms. Sanchez. Thank you, Ms. Barrera-Solis. Y'all are out of here.
Thank you. May we
Thank
be
you.
excused?
You betcha.
Okay.
Mr. Coronado, are you ready to proceed on Mr. Longoria?
Ready, Your Honor.
Got cause 641-925 and 642-678. Cause 641-925 is a motion to revoke community supervision. Cause 642-678 is a motion to revoke community supervision. Starting with cause 641-925 and including 642-678 with regard to these documents, The first document on each case is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference, which is reportedly signed both by Mr. Longoria and his attorney, Mr. Coronado. Mr. Longoria, is this your signature on both these documents? One in cause 641-925 and one in cause 642-678.
Yes, sir.
Thank you. And Mr. Coronado, as attorney for Mr. Longoria on both these cases, is this your signature also on each document, one for cause 641-925 and one for cause 642-678?
That's correct, Your Honor.
Thank you. The next document I have, one for each case, is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked in each case, quote, is a revocation of the defendant's community supervision, and the defendant has the right to appeal the court's actions revoking the community supervision, but not the underlying conviction. In fact, Mr. Longoria, on both these documents, one in cause 641-925 and one in cause 642-678, is this your signature on this on these documents also, sir?
Yes, sir.
Thank you. And Mr. Coronado, as attorney for Mr. Longoria, are these also your signatures on both these documents?
Yes, Your Honor.
In cause 641-925, this is a motion to revoke community supervision. My understanding is this is an uncontested motion to revoke community supervision. Mr. Coronado, is that correct?
That's correct, Your Honor.
And when we get there, Mr. Coronado, in cause 642-678, is that also an uncontested motion to revoke community supervision?
That's also correct, Your Honor.
All right, thank you. Mr. Longoria, in cause 641-925 on the motion to revoke community supervision, how do you plead, sir?
Guilty.
No, true.
True.
All right, court accepts the plea of true in cause 641-925. Ms. Gross, would you please advise the court and the parties of the status of Mr. Longoria's probation in cause 641-925? I remind you, you're still under oath.
Yes, Your Honor. Thank you. Mr. Longoria was placed on probation on April 5th, 2022. Multiple attempts were made to communicate with him to set up his orientation. He failed to report to sign his conditions multiple occasions. There's been no effort to make any payments. He has a balance of $825. He's delinquent $101. He owes 80 hours of community service. We have no proof of enrollment or completion of the theft class or proof of a Texas driver's license. This is his first violation report, first MTR. His arrest history includes terroristic threat, possession of a controlled substance, penalty group 1 to 4 grams, theft of person, possession of a controlled substance, penalty group 1, less than 1 gram, theft 100 to 750 times 3, driving while license invalid, enhanced, possession of a controlled substance, penalty group 1, less than 1 gram times 2. Probation is recommending revocation.
And Mr. Coronado, what are you requesting with regard to Mr. Longoria's case in 641-925?
Your Honor, request since you deny the MTR, continue on probation with the stern warning that he has to go to orientation. He had some problems earlier with not reporting. He said he had his phone. He can explain it to you, but he had problems with his phone, and consequently had a death in the family. So he kind of put it on the back burner. But now, after spending, he's got 15 days credit right now in jail. He said that if he's given another chance to get out there, he will, abide by all conditions of probation. He will go to orientation. He'll do everything that needs to be done. Is that correct, Jose?
Yes, sir.
Explain to the judge why you missed the orientation.
I tried doing orientation through the phone, but my phone was messing up, and I was getting reset to go in person, but I had a death in my family, and it just sidetracked me through a lot of things, But if I get the chance to, and I apologize for not being able to showing up to my orientation, but if I get the chance to do it again, to be on probation again, or get out there in the world, I'll multiple try to do my best, way better than what I was doing it before.
Ms. Gross, I got a question for you. He's got 2 separate dates that he's alleged to have failed to attend orientation. I guess my question is, was his original date that he was told to report for orientation April 12th, 2022, and he didn't report on that date, so they gave him an alternate date of April 18th, 2022, and he also didn't report on that date? Is that what we're dealing with?
Right. To give the entire context of the situation, Judge, On April 7th, he did call in on Zoom for his orientation appointment. And evidently he was in a bad area and he kept freezing and having connection issues. They couldn't hear him. So he was advised that he would be rescheduled. He was then given that second appointment to show up on April the 12th. He neglected to do so. He was then given another appointment on April 18th. He neglected to do so. In addition to that, I'm showing in his record, which I'm reading right now, there were letters sent to his home and there were multiple phone calls where they left messages and spoke to family members, and the family members assured that they would pass on the information. And many times the calls went straight to voicemail, and it showed that that mailbox was not set up, so they could not leave a message, hence why the letters were mailed, as well as some text messages.
A question for Mr. Coronado and Mr. Longoria. Do you agree with Mrs. Gross or Ms. Gross's representation with regard to the dates of April 12th and April 18th?
I believe so. That's when he had the death in the family, and that's the reason why he did not report on those
All
2
right,
days.
so what date did he have? And I'm sorry he had a death in the family. What date did that happen?
The date of my family was before the second day of I was supposed to go report in person. You know what I mean? My phone actually broke on me. That's why I wasn't able to report on through the phone. I didn't get to see my messages. I'm still trying to get a brand new phone right now as we speaking. You know what I mean? My wife is trying to get me a new phone. I did see the paperwork of the court, but you know what I mean? Through the death of my family, everything went sidetracked in my head. You know what I mean?
Okay, Mr. Longoria, and once again, I apologize you had a death in the family, but what date did you have a death in the family that caused you to miss at least one of these appointments?
The day before my appointment on the second one.
On the 18th, so you had a death in the family on the 17th?
Yes, sir.
Did you call the probation department and explain what was going on?
I didn't have a phone to call in. I was trying to get a hold of a phone, but I couldn't get a hold of none of my family members at the time.
Okay.
And Judge, if I may, I was also in contact with the defendant's attorney, Mr. Coronado, and I had advised him of the impending MTRs and suggested that he contact his client. And I do believe that he reached out to a family member. He can elaborate on that should the court want to inquire with counsel.
Okay, well, I've got the story, I think, correctly. Mr. Coronado, anything further?
Nothing further, Your Honor.
State recommendation on Mr. Longoria and cause 641-925.
State recommends revocation.
Mr. Longoria and cause 641-925. The court accepts your plea of true with an explanation. I grant the state's motion to revoke your probation. I sentence you to 6 months in the Bexar County Jail. It sets a $450 fine plus court costs. Recalling all pretrial services, bond conditions, and warrants. This case to run concurrent with 642-678. Although I have the authority to sack you and make you do 6 months on each case, but instead your attorneys convinced me you deserve a little slack, so we're going to just run them consecutive or concurrent rather. Anything further from the state of the defense on Mr. Longoria and 641-925?
Nothing from the state, Your Honor.
Nothing further, Your Honor.
Mr. Longoria, cause 642-678. This is also a motion to revoke community supervision. And how do you plead on this case, sir?
True.
Thank you. And Ms. Gross, is there any variation on the theme on 642-678 from 641-925 as already represented?
No, Your Honor, probation will provide the same supporting evidence as stated in the case prior.
And defense, anything further with regard to your request on this case that was maybe a variance from the other case?
No, same request, deny NPR and continue on probation.
Okay, state, same recommendation, new recommendation?
Same recommendation, Your Honor.
I don't know if I got this the last time or not, but on cause 641-925, it was credit for time served, time and money to run concurrent. Mr. Longoria, in clause 642678, court accepts your plea of true. I grant the state's motion to revoke your community supervision. I sentence you to 6 months in the Bear County Jail. It says a $450 fine plus court costs, credit for time served, time and money to run concurrent with 641925, recalling all pretrial services, bond conditions, and warrants. Anything further from the state or the defense of Mr. Longoria on 642678?
Nothing from the state, Your Honor.
Nothing further, Your Honor.
Good luck, Mr. Longoria. Thank you, Mr. Coronado. Y'all are dismissed.
Yeah, am I going to break out room with my client to talk to you before I leave?
Absolutely. Sure, you bet.
All right, thank you.
Hold on, Todd. I will put you back where you were in room 5.
Thank you.
Okay, and Pat, I have paperwork on who now that I have not looked up. Is it Chavez? Or
Chavez has not signed his paperwork, Your Honor.
about Bentello?
Mr. Jax has signed his paperwork. You should need to sign it, though.
All right, so I have
Mr.
Jax.
Bunteo- Uh-huh.
Go ahead.
Mr. Bunteo has also signed his paperwork, but you have not. And then you have all the others, Mr. Juarez, I sent to you. You've already signed it. You just need to print it.
All right, take a 5-minute break. Let me do all that. I'll be right back.
Pat, this is Barry Hitchens. You can put me back in the room with Mr. Chavez. I can see that he signs the paperwork.
Okay, I will do that right now, Mr. Hitchens.
Thank you, Pat.
Pat, I believe Monica and Mr. Jax both signed.
Yes, you're fine.
Okay, good.
It
Thank you.
is, judge has not signed it. That's
Oh,
the,
I understand. Okay, very good.
okay. Mr. Hitchings going to 8. Let me put Todd. Okay. Todd go into 9. Longoria go into 9. There you go. Mr. Longoria, you should have a button to go into a room. Please go into that room so you can talk with Mr. Coronado.
Yes, ma'am.
Should be a button.
I do not see it, ma'am.
I moved you into room 9, so you should be there. The button is, yeah, there should be a blue button that says join. And, or something that says for you to go into a room, a breakout room.
Let me see if I can get some help, please.
Okay, that's fine. I'll let Mr. Coronado know that's what you're doing.
Okay, showtime. Are we ready on cause number 643267, State of Texas versus Tony Jacks? Mr. Statesman?
We're potentially, so.
I'm sorry, Mr. Statesman, are you ready on Mr. Jack's case?
Yes.
All right, thank you. This is cause number 643267. This State of Texas versus Tony Jacks. This is a motion to revoke community supervision. The first document I have on this case is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference, which reportedly has both Mr. Jack's signature and Judge Monica Guerrero, Mr. Statesman's trial partner's signature. In fact, Mr. Jacks, is this your signature on this document, sir?
Yes, sir.
And Mr. Statesman, is this Judge Monica Guerrero's signature on this document?
Yes, it is.
Thank you. The next document I have for you, Mr. Jacks, is entitled Trial Court Certification of Defendant's Right of Appeal. And Pat, administratively, at the very top left of this document where it's supposed to have the defendant's name, it has the number 643267. So
Okay.
that's not, just correct and put his name in there for it.
I will.
Anyway, this is a trial court certification of defendant's right of appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions, revoking the community supervision, but not the underlying conviction. In fact, Mr. Jackson, is this your signature on this document also, sir?
Yes, sir.
Thank you. And Mr. Statesman, is this Judge Monica Guerrero's signature on this document also?
Yes, Judge.
Thank you. Mr. Statesman, my understanding is that this is going to be an uncontested motion to revoke community supervision. Is that correct?
Correct.
Mr. Jackson, cause 643267 on the motion to revoke community supervision. How do you plead, sir?
True with explanation.
Thank you, sir. Ms. Gross, would you please advise the court on the parties of the status of Mr. Jack's probation? I remind you, you're still under oath.
Those are cases that got appealed where appeals
Mr.
judges.
Stevenson, can you please mute yourself? Thank you. Yes, Judge. Mr. Jack's reporting was good. We last saw him on December the 8th, 2021. He paid in full. He completed all 24 hours of his community service as well as his stress class. However, on December 14th, 2021, there was a VR MTR sent to the court, and in lieu of filing a motion to revoke, the court graciously ordered that the defendant do weekly drug testing in lieu of that. And on December 21st, he signed alternate amended conditions acknowledging that. However, he never followed through, and he had 4 failure to submit, 1 diluted drug test, and 7 negative tests. His criminal arrest history includes 6 burglary of a vehicles, theft $1,500 to $20,000, burglary of a building with intent, theft $50 to $500, possession of marijuana, 3 DWIs, evading arrest, and this case that we're here today on resisting arrest. His officer is recommending that his case be extended for a period of 1 year, that he be placed on weekly drug testing. Now, keep in mind, this case did expire January 6, 2022.
Okay, and the MTR was filed on or about December 22nd, 2021. Does that sound right?
Yes.
And the last time y'all heard from the defendant was in December of 21, December 8th, it looks like?
Yes.
Okay, I got you. All right, Mr. Statesman, what are your requests?
Judge, we're asking that you follow the extend 1 year, add the additional condition, weekly UA, and Mr. Jack's defense, 11 solid months reporting. There may have been one July 2020, one July missed UA test, but all the other ones from February up to I think November were all negative. He insists he doesn't have a drug problem or alcohol problem, and the one diluted, it was because he works construction outside. He's worked in a commercial AC field for the last 12 years. He's had a job opportunity with Tesla to work on AC systems, to design stuff with Tesla. He's motivated to finish probation. He doesn't want to be revoked. He did 11 months. He never absconded. He didn't realize that he had to have a date for UA testing other than one of them, or he will admit that he had a schedule conflict. He needed to have it rescheduled. He did speak with his probation officer December 9th, I believe. And they gave him, allegedly they gave him a new date, but he says he was not aware of that. But 95% compliance, Judge. We're asking that you just follow the recommendation, extend 1 year, let him finish it, let him keep his job.
And state recommendation, please.
They recommends revocation, Your Honor.
Mr. Jackson, cause 643-267. The court accepts your plea of truth and explanation. I grant the state's motion to revoke your probation. I sentence you to 6 months in the Bexar County Jail. Although I have this is a class A, is it not resisting?
Judge, they capped it at 180, considering he had substantial compliance. Would you give him less than the 180, please, Judge?
Is resisting arrest an A or B these days?
It is an A, but he was capped at 180 days previously.
6 months Bexar County Jail, $200 fine plus court costs, credit for time served, time and money to run concurrent, recalling all pretrial services, bond conditions, and warrants. Anything further from the state of the defense on Mr. Jack?
Nothing from the state, Your Honor.
Aside from the sentence, Judge, the 180, in your discretion, Mr. Jacks is asking for, I believe, 30 days. He has a child and a job that he could lose.
Okay, defense, do you agree with me that I could sentence him to a year if I wanted to?
It is a class A, yes, Judge.
So aren't I being kinder and gentler by sentencing him to only 6 months to give him credit for some of the things he actually really did?
I agree.
Whether you understand it or not, I am. So good luck, Mr. Jacks, and thank you, Mr. Statesman. Y'all are dismissed. Okay. Ready on Mr. Bentello? Just, Ms. Garcia, do you have a motion or you wanted a continuance, or what did you tell me earlier, Teresa? I apologize, I couldn't hear you.
No, Judge. He's got a new case, and we wanted to see if we could take care of the new case as well today. I don't know if we can or cannot.
You want a continuance on his motion to revoke probation on the old case because he has a new case? Is that it?
No, sir. We're moving forward on the MTR, but I was wondering if we could also take care of the new case.
Oh, okay. Well, we'll see how it comes out. And if he gets revoked, you can certainly ask the state if they will allow me the TIC, the second one, if that seems to be in the interest of justice in the state's mind. And that's a possibility. Is that what you're looking for?
Judge. Let's do that.
All right. Thanks. Okay. This is cause number 656350, State of Texas versus Ryan Buntello. And represented by Ms. Teresa Garcia. This is a fifth amended motion to revoke community supervision. First document I have on this case is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference, which purports to have both Mr. Buntello and Ms. Garcia's signature on it. In fact, Mr. Buntello, is this your signature on this document, sir?
Yes, sir.
And Ms. Garcia, as attorney for Mr. Buntello, is this also your signature on this document?
Yes, Judge.
Thank you. The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal. And mine doesn't even seem to be marked, but it should be marked. Is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction. And I apologize, guys, we're getting a lot of background noise. If I'm not specifically talking to you at this time, please turn your microphone off and you can turn it back on when we are talking. So Pat, administratively, on the trial court certification of defendant's right of appeal.
Yes.
It needs to be marked, quote, is a revocation of the defendant's community supervision. 1,
Yes.
2, 3, 4 from the bottom.
Yes.
Other than that, it's fine. Okay, on this document, is this your signature on this document also, Mr. Buntello?
Yes, Your Honor.
Thank you. And Ms. Garcia, is this also your signature on this document? Ms. Garcia?
Oh, I'm sorry. I muted myself to help you out. Yes, Judge, it is my
This is your
signature.
signature? All right, thank you. Ms. Garcia, my understanding is that this is going to be an uncontested fifth amended motion to revoke community supervision. Is that correct?
Yes, Judge, we're agreeing true to one of the number twos.
Okay, Mr. Buntello, and cause 656350 on the fifth amended motion to revoke community supervision. We're still getting background noise, guys. Everybody turn your microphone off, please, unless I'm actually talking to you and you need to talk back. Mr. Buntello, and clause 656350 on the fifth amended motion to revoke community supervision. How do you plead, sir?
True.
Thank you. Ms. Gross, would you please advise the court on the parties of the status of Mr. Buntello's probation? I remind you, you're still under oath.
Yes, Your Honor. Mr. Buenteo has performed very poorly on probation in that he only ever reported 3 times. His case did expire March 24th of 2022. We have not seen him since June 2nd of 2021. He has been arrested and charged with a new failure to identify, which is not alleged on the motion as it occurred 2 months after his probation expiration, but that case is showing that is still pending. He only paid $167 towards his fees. He has a balance of $980. We have no record of him completing any of his 24 hours community service, victim impact panel, or CATSNP program. He did complete the DWI education. He has 4 positive drug tests for alcohol, 2 failure to submits, 0 negatives, and he failed to show up for a UA on 1 occasion. He was on Smart Start Mobile where he was testing 4 times per day, and he had 50 skip tests, 4 high BRACs. Initially, he failed to install his device within the court-ordered 5 days. On May 24th, 2021, he had a high BRAC of 0.097. June 3rd, 2021, 0.022. June 20th, 2021, 0.062. July 10th, 2021, he had a 0.112. And then he has been in lockout on the device since November the 16th of 2021. His officer is recommending that his probation be extended for a period of 18 months. He be sent to SATF for 120 to 180 days, followed by aftercare. Or if the court does not wish to do that, extend him for a year, put him on Scram and the UA call-in line for a period of 60 days. His criminal history includes 1 arrest for prostitution, theft $750 to $2,500, and failure to ID on 3 occasions.
Ms. Garcia, what are you requesting, please?
Judge, I am requesting that he be revoked and that he be given 84 days in the Bexar County Jail. And that his new case, if the DA is so inclined, to be taken into consideration.
State recommendation, please.
State recommends revocation and no objection to taking into consideration that failure to ID case.
Okay. Mr. Buentello, in cause 656350, the court accepts your plea of true. I grant the state's motion to revoke your probation. I sentence you to 6 months in the Bexar County Jail, assess a $300 fine plus court costs, credit for time served, time and money to run concurrent, taking into consideration cause 684-741, which is granted, and it shall be dismissed, recalling all pretrial services, bond conditions, and warrants. Anything further from the state of the defense on Mr. Buentello?
Nothing from the state, Your Honor.
No, Judge.
Good luck, Mr. Buentello. Thank you, Ms. Garcia. Y'all are dismissed.
Mr. Buenteo, I will be doing a Smart Start removal order. It will be in your file and it will be sent over. So maybe sometime next week, if you have a family member that can locate that, they can take it back to Smart Start.
May I be excused, Judge?
Yes, Garcia, can I speak to you?
Pat, did we ever get the documents for Mr. Chavez's case?
Not yet, Your Honor.
All right.
But I can,
They're still in a breakout room.
All right.
Real quick, Pat, my client has asked to speak to me. Can you put us back in a breakout room?
Of course, I will.
Thank you.
All right. Are we ready on cause 671-400, State of Texas versus Tanisha Martin with Mr.
We are
Stevens?
ready, Your Honor.
All right.
My client and her father in my office, we had sent the court a handwritten letter from her father, which you have in front of you. If the court would make itself aware of that, the state also has a copy of it.
This is cause 671-400, State of Texas versus Tanisha Martin. This is a motion to enter adjudication of guilt and revoke community supervision. The first document I have on this case is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference. It purports to have both Ms. Martin and Mr. Stevenson's signature on it. In fact, Ms. Martin, is this your signature on this document, ma'am?
Yes.
Thank you. And Mr. Stevenson, as attorney for Ms. Martin, is this also your signature on this document?
It is, Your Honor.
The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is an adjudication of guilt following a deferred adjudication, and the defendant has a limited right of appeal, unquote. Ms. Martin, is this also your signature on this document, ma'am?
Yes.
And Mr. Stevenson, as attorney for Ms. Martin, is this also your signature on this document?
It is, Your Honor.
Mr. Stevenson, my understanding is this is going to be an uncontested motion to enter adjudication of guilt and revoke community supervision. Is that correct?
We have an agreed recommendation with the state involving the continuation of her probation. So if that's what you're asking, then yes.
Okay, well, as you're well aware, I'm not bound by any agreement you may make with the state regarding the results of a motion to enter adjudication of guilt and revoke community supervision. I'll be happy certainly to hear from both sides what the recommendation is, and if y'all have an agreement, I'll be happy to listen to it, but I'm not bound by that. You understand that, Mr. Stevenson?
Yes, Your Honor.
And you understand that, Ms. Martin?
Yes, Your Honor.
Thank you. So once again, is this going to be an uncontested motion to enter adjudication of guilt and revoke community supervision? Obviously, she can plead true or not true with an explanation any way you want to do that, Mr. Stevenson.
I don't believe that we do not contest most of the items. There's one item on there that is an error on the MTR, but everything else we're going to plead true to.
All right, and which item are we talking about that she does not want to plead true to?
Okay, condition number 16, it talks about failure to have CAT-SNP completed. I've looked at the terms and the conditions, and other than her probation expiration date, there is not a specific deadline to have CAT-SNP completed. She has completed all her other classes, and my understanding from her probation officer is that her probation officer, Daniel Ovalle, is satisfied with her progress in her classes. But that one, there is no deadline yet. Everything else we're pleading true or true with explanation.
All right, why don't we just, if this is what you're telling me, she can plead true with an explanation to everything except 16, and we won't plead anything to 16. Will that be equitable to the defense?
Actually, we'll do better than that. We'll plead true with explanation to 13 and true without explanation to everything else, but we will have some argument for the court and some background information and a solution that we believe the court will find acceptable.
All right, and let me back up. You're pleading true to 13 and what else, 14? And there's several 14.
We're pleading true to everything except for 16, Your Honor.
All right, all good. Ms. Gross, would you please advise the court and the parties of the status of Ms. Martin's probation, please?
Yes, Your Honor. Ms. Martin has been reporting as directed. We last saw her May 17th, 2022. She has paid $123 towards her fees, has a balance of $1,154, and is delinquent $101. We have no record of any of her 48 hours community service having been completed. She has completed DWI education, victim impact panel, and we have no proof of enrollment or completion of the CAT-SNP program. She's had 2 positive drug tests, 1 for marijuana, 1 for alcohol. She's currently on a Smart Start mobile device where she's testing 4 times per day. At the time the motion was filed, she had 11 skip tests. She has now had an additional 8 skip tests since the motion was filed. 1 high BRAC, which occurred on April the 3rd, 2022 at 0.08 at 6:55 p.m. She has no criminal history. Her officer is recommending that her Smart Start mobile device be increased to 6 times per day and that she be placed on weekly drug testing.
Your Honor.
Sure, go ahead.
I would like to speak to the allegation that there was a positive test for marijuana. I'm aware that my client does have an issue with anxiety. I'm aware that my client uses perfectly legal and legally purchased hemp products, specifically Delta 8, which is not federally or state illegal, although it is capable of sometimes producing a false positive on a test for marijuana. I've spoken with her at length on the issue, and I'm convinced that she is not using a cannabis sativa in any form or any of its derivatives, and that everything that she's using is legal. I can provide a photograph of the packaging of the product that she does use. It is Delta 8 and it is legal. Since this was not listed on this motion to revoke, I did not send that to the court at this time, but I can provide it.
I think I'm more concerned about alcohol consumption blowing legally intoxicated on the machine. Can you address that for me?
Yes, Your Honor. My client has a bigger problem with alcohol than she thought she did. Within the first month of being on probation, before she could have the benefit of all the programs, yes, she did go ahead and do the DWI program, the Victim Impact Panel, which deeply moved her, and she's told me about the Victim Impact Panel. It really changed her mind about several things. She's not been able to get through the CATSTIM program yet. She had not had her first meeting with her probation officer yet. However, she was living and working in living and trying to work in San Antonio, where her family was not, and where she did not have a strong family support structure. Part of the solution that we have that we would like to ask the court to consider today and follow is letting her move back home. I have met her father. Her father's in my office. He is a retired Navy sailor who spent 6 years working on the U.S. Enterprise. I'm trying to say USS, and actually probably that is correct too. But I hope you'll speak with him. He's very interesting to talk to, and he wants her to come back home. She wants to come back home because she really wants to succeed, and she does not want alcohol making the decisions about her life.
And where's Ms. Martin? Where's Ms. Martin living currently?
Her lease in San Antonio is ending, and one of the reasons her dad is in town is to get her things and help her move to Lufkin. But we need to make sure that the court will allow her to move back home, and then see if the court also wants to transfer her probation to Angelina County, CSCD, which is in Lufkin, Texas. There is a Smart Start location in the city of Lufkin. I have already looked that up.
Okay.
You have a letter from Joe Martin, who is the dad. I would also encourage you to speak with him if you have any questions for him. He's across the desk from me, and he will gladly address the court.
And who is Mr. Martin? I'm sorry, this is her father?
Biological father. She grew up in his home.
In just a few moments, I'll be happy to chat with him.
Very good.
Anything further from the defense at this time? Did you want to call your client's dad as a witness and do that way, or how would you want to do that? You can do it any way you want. You can do question, answer, or narrative, and the state won't have any problem with that if I were guessing. Is that correct, Mr. Reed?
That's correct, Your Honor.
Everything that I would question him under oath is already contained within the letter. So we want the court to get the information. Since this is not a jury trial setting, we are less concerned about how the court gets the information. We just want the court to know everything that is in the letter and to speak with Mr. Martin to where it's confident that he means everything he says and that it's a good situation.
Mr. Reed, have you had a chance to read Mr. Martin's letter?
Yes, Your Honor.
All right, well, let me read it real quick and then we'll chat about it.
Very good.
Okay, state recommendation, please.
State recommends substantial compliance within 10 days, weekly UAs, and increasing the Start mobile to 6 blows a day.
Mr. Stevenson, let's say in the highly unlikely event you have convinced me to not revoke Miss Martin and put her in jail for 6 months, would she be willing to volunteer to go on the Scram Cam ankle bracelet device for at least 90 days? If she does well in 90 days, we'll put her back on the Smart Start. But I can't get her to blow in the Smart Start mobile reliably right now. And I've got what, 11 original and then 8 further, so 19 skips. If I can't get her to blow in the machine, I can't monitor what she's doing.
Your Honor, our highest priority is that she get to move back home and rebuild her life in a healthy family environment back in Lufkin, Texas. We understand that the court needs additional assurances. We also understand that when Smart Start has not worked as the court wanted it to, a little bit more structure is necessary. If that is what the court believes is best, we would not object to that.
All right, thanks. And State, I apologize. Did I already get your recommendation?
You did, Your Honor.
Okay, and that was an agreement you had with the defense, even though I'm not bound by it. Is that correct?
That's correct, Your Honor.
Okay.
That was a loose agreement. The agreement that I had understood was simply the recommendation of probation, which was increased from 4 to 6 test windows per day, 2 months of clean testing to go back down to 4 tests a day, and then weekly UAs until we've got 4 clean UAs, then back to monthly. That was what I understood was going to be recommended this morning, because that's the probation court summary.
And substantial compliance.
Susan, what was the original fine amount on this case, if you know?
Let me get that for you, Judge. I have it right here.
I've got it, $600. Thank you. You
There
told me
go.
where it was last time. And was there 48 hours community service probably on the original plea?
Yes, Your Honor, 48 hours community service. And then the standard programs, DWI, victim impact, and CATSNP. And if the court does so choose to transfer her back to Angelina County, she can do the CATSNP program via Zoom.
Can she do intensive outpatient with CATS via Zoom?
That I don't know. I would have to call Dean real quick.
Mr. Stevenson, has Ms. Martin already started the original CATSNP program, our outpatient drug program, or she hasn't started? She's only been on probation 3 months, it looks like.
She has not started those programs. She has completed the victim impact panel and the DWI education in her first month. That's all that has been done so far, but her plans are to comply fully.
What county is Lufkin, Texas in?
Angelina County, Texas. Population 87,000.
Wow.
But they have their own Smart Start, they have their own CSCD, and I'm certain that they have an intensive outpatient option.
Yes, Judge. Most counties do have an intensive outpatient available, and if she is formally transferred up there, then they will send her to the local program up there in Angelina County. The only class she would need to be doing here would be the CATS NIP, which can be done via Zoom.
And Your Honor, the decision to transfer the probation is entirely up to the court. She has 11 and a half months of probation left. I don't know if she would have to be extended for an additional month in order to transfer the probation, but I wanted to bring that to the court's attention because we're just under 12 months.
Okay. Mr. Stevenson, do I have your permission to talk to Mr. Martin at this time?
Please do. I'm going to hand the phone to Mr. Martin.
All right.
He's centered in that small square up in the top.
Hey, Mr. Martin, thank you. Thank you for being with us today, and thank you for volunteering to assist us in trying to keep Miss Martin out of trouble. What did you do in the Navy, sir?
I was a nuclear power plant operator.
Were you on like a submarine or were you on land somewhere?
Aircraft carrier, USS.
Oh, okay. Well, wonderful. Well, thank you for your service, sir. Are you retired from the Navy now?
No, I'm not retired. I did 6 years and I continued on in civil service. I hope to retire from that within 2 years.
Okay. And my understanding in reading your letter is that you're volunteering to allow your daughter to, and I guess her significant other, to come live with you in Lufkin, Texas. Is that correct?
That is affirmative.
All right. The big issue, I guess the elephant in the room we're dealing with is she has a very severe drinking problem, best I can tell. I assure you, she has a very, very high-speed attorney, and he has warned her in the past about what a mean judge I am, and if she violates, she's going to go to jail. Would that be accurate, Mr. Stevenson?
Yes, Your Honor. I've
All
scared
right.
her.
yet she's still drinking. So that's what concerns me. I can't stop her from drinking. So I'm going to give her over to you and let you put her on double secret probation under you and see how she does. I'm not doing well under me. All right.
Several conditions.
Do you have any
she left
questions?
with you too.
Do you have any questions for us, Mr. Martin?
No, sir, I don't. Thank you.
Okay. Ms. Martin, in cause 671-400, the court accepts your plea of truth with an explanation to all allegations except for number, what was it? 16. I grant the state's motion to revoke your deferred adjudication probation. I adjudicate you guilty of the offense of driving while intoxicated. I sentence you to 6 months in the Bexar County Jail, probated for 1 year. A $600 fine plus court costs, 48 hours community service, DWI education, DWI victim impact panel, Community Alliance for Traffic Safety intensive outpatient or equivalent in Angelina County. I'm gonna order the Scram Cam device, which costs plus or minus $300 a month for at least 90 days. I'm just ordering it, Mr. Stevenson, which means it's gonna go to the end of probation. However, if she does well on it and we have no violations in 90 days, I would like you to approach me and bring this back to my attention. And the probability is we will switch her from the Scram Cam device to the Smart Start Mobile as long as you can convince her to blow in the machine. That sound fair?
Yes, Your Honor. I will continue in contact with her and encouraging her to comply.
All right. And Susan, since she has a full year to go now, I assume we can transfer to Angelina County?
Yes, Your Honor. And in regards to that Scram device, in order to avoid any conflict, may I suggest that she be given 10 days to obtain that device so that she can get it up there and rather than down here?
That's a good question. Mr. Martin, how soon is your daughter planning to move to Lufkin with you?
Today, sir.
All right, all good.
Your Honor, may I ask the court, does it give my client permission to relocate to Angelina County?
Absolutely. And what we're going to do is I'm going to order Scram Cam. She stays on the Smart Start Mobile and needs to blow in that reliably until the Scram Cam is active. Then she can turn in her Smart Start Mobile. So we get coverage on her. State, what did I miss?
That's everything, Your Honor.
All right.
Your Honor, we would ask that the DWI education program and the victim impact panel from her deferred adjudication be carried over.
Absolutely. She gets credit for anything she's done, any programs completed, any money's paid, that sort of thing. Any community service hours done, anything in that regard that she's already done, she certainly gets credit for.
Very good. Also, may I ask a question? Would the court give us direction with regard to the therapeutic use of Delta 8? I'm certain that the court has heard of Delta 8. Does the court have opinions regarding Delta 8?
Is this the cannabis stuff?
It is similar to, it is a CBD product, but it's made from hemp, not cannabis sativa.
Okay, this is sort of a gray area in the law, as you of all people are well aware. I don't think I have the authority to order somebody not to use something that is a medical prescription. I do have the authority to order them not to use something that's over the counter. But if it's a medical prescription for some sort of product that's going to test positive for marijuana, I don't think I have the authority to stop her from doing that. Otherwise, I don't want her doing anything that's going to make it look like she's smoking marijuana if she's not smoking marijuana. And I don't think I have any way to tell. Susan, is there any way to differentiate between marijuana for pleasure and marijuana for medical purposes?
No, Your Honor, there's not. And the CBD products and the Delta 8, which defense counsel speaks of, it is going to test positive, and there are no prescriptions for those two particular products.
My suggestion,
sounds like we need to avoid them then.
Yeah, my suggestion, Mr. Stevenson, is she finds something in an alternative basis for the next year or so while she's on probation. And when she's off probation, she can do pretty much whatever she wants. How's that?
I agree. I will pass that on to her. Thank you very much for sharing on that one.
Do I have your permission? Do I have your permission to talk to your client briefly?
Yes, Your Honor. I'm going to hand the phone to her.
Hey, Ms. Martin, your attorney and your father have just saved you, basically. So that being said, that just saves you today. That doesn't save you tomorrow. This same type of activity that we're doing, this motion to revoke probation, can come back again. I've got a 6-month hammer over your head. I would like you to have a very short conversation in private with your attorney who knows me very well. And he will be happy to relate to you the fact that in all probability, if anything goes wrong on your probation from this point forward, you're likely looking at a 6-month jail sentence. And you don't want to do that, and I don't want to do that. And I have the authority right now to put you in jail for 30 days just to get your attention. But I can't really do anything worse to you than send you home with a Navy father. So I'm thinking that's probably going to have some impact on you. So instead of 30 days in jail, I'm going to order you to live with your dad. And that's about the most brutal thing I can do to you right now to try to keep you straight. I think you have a serious drinking problem. You're the only one who really knows, but you got to stop drinking. So whatever you need to do to stop drinking, if you're having a problem and you know you're going to drink, and you know if you drink, you're going to violate, and if you know you violate, you're going to have an MTR and I'm going to put you in jail. Yeah, you still have to drink. That's a very severe drinking problem. So you might, Mr. Stevenson, you might look at the possibility if they have any short inpatient programs over in Lufkin. I know the VA has a 30-day one or something like that. But I don't know that in the real world they have anything like that. I don't know what Lufkin has on inpatient. But we don't have to do that immediately, but that's my backup plan instead of putting her in jail if it comes to that.
Well, Your Honor, I understand that her father is already looking into options like that and is planning to add additional conditions and additional requirements for her continuing to stay with him. So the court is not the only one that's going to be ordering her to do certain remedial things on this, Your Honor. Her dad is all over it too.
All right. Anything further from the state of the defense on Ms. Martin?
Yes.
Sure.
Ms. Martin, because you're going to be starting all over on probation, Ms. Benavides has already mailed you paperwork, and it is your application for probation and a new data sheet. You need to fill both of those out, okay? Then probation will be in touch with you probably within the next 48 hours. If you don't hear from them by next Tuesday morning, you need to either reach out to Mr. Stevenson or call the probation department at 210-335-7446. Let them know that you are placed on probation and you need an orientation appointment. It's your responsibility to make sure that those new conditions get signed. They'll give you all of your referrals. You need to remind them that you are going to be moving out of county and that you need an out-of-county referral for that Scram device as soon as possible, okay?
Did you say that the stuff was gonna be mailed or emailed?
No, it'll be
Okay, the
either
paperwork-
Email?
The
Okay.
paperwork, the new application for probation and the data sheet has been sent to your attorney's email first, so he can fill out just a few items, cause number, name, that kind of thing. And then it will, after he does that, it will be sent to the other email where you signed that mail defense. Then you need to fill out the rest of the information, which is a new data sheet.
I have it, Pat. I have it. We'll do it right now, just as soon as we get off Zoom.
Thank you,
Perfect.
Mr. Stevenson.
All
I
right.
appreciate it.
And do you have any questions, Ms. Martin?
No.
Okay, good luck to you. Thank you, Ben.
Thank you very much. May we be excused.
Hang on just a second. Susan, she's going to need to appear on Zoom or in person with the probation department before she leaves for Lufkin. What does she need to do?
Because it's a transfer. That's a good question. I think it'll all be done via Zoom. I think they're doing everything Zoom now.
All right. Well, she really needs to know before they get in the car and drive to Lufkin. If she needs to do something here, we've got her here now. We need to do it.
She's downtown. Would probation like her to stop over in person? She's downtown already.
Hang on one second. Let me email my source here. Or text her. It won't take me but a second.
The only problem with that is the judge will not have sent all the information regarding the revocation and regular probation to the clerks to put into the system. So probation will not know any of that or what the conditions are.
Understood.
Okay. So let's just do it by Zoom, wherever that is, Susan. Will that work?
Okay, that's fine.
All right. Y'all are dismissed. Thank you. Good luck.
We'll get this signed and I'll also keep it on my calendar to contact you in 3 months, Your Honor. Thank you.
Okay, and I'm looking, Pat, I just signed some paperwork on Mr. Chavez, I think. So let's take a 5-minute break while Pat sends me these documents, and then we'll resume. Take a break, smoke them if you got them. Okay, Mr. Hitchings, you ready to proceed on Mr. Chavez? And your microphone's turned off, Barrett.
There we go. We are, provided the court has all the paperwork, he sent it to the court from the jail, so.
Yeah, I've got it. We're good. Okay, this is cause number 647-640, State of Texas versus Jonathan Chavez, represented by Mr. Barry Hitchings. This is a motion to revoke community supervision. Mr. Chavez and Mr. Hitchings, the first document I have is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference that purports to have both your signatures on it. In fact, Mr. Chavez, is this your signature on this document, sir?
Yes, that is my signature.
Thank you. Mr. Hitchings, as attorney for Mr. Chavez, is this also your signature on this document?
It is, Your Honor.
And the next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction. In fact, Mr. Chavez, is this your signature on this document also, sir?
Yes, Your Honor, that is my signature.
Thank you. Can you turn your camera on, Mr. Juarez? There you are. Thank you, sir. Okay, Mr. Hitchings, is this your signature on this document also, sir?
It is, sir, or it is, Judge.
Thank you. Mr. Hitchings, my understanding is that this is going to be an uncontested motion to revoke community supervision. Is that correct?
Well, the notice I got from the court on the court summary was they agreed to continue him on probation.
I think that's the recommendation of the probation officer. Susan, would that be accurate?
Yes, that's what his officer is recommending.
So obviously I get to hear your recommendation and the state's recommendation and the probation officer's recommendation, and then I do whatever I want to do.
Right. So as far as the defense is concerned, as far as revoking him, we would contest that.
Well, that's not what I'm asking you. Here's what I need to know. He either pleads true or not true. He can request a fully contested motion to revoke community supervision. And the only real difference that I'm unaware of between a fully contested motion to revoke community supervision and otherwise just pleading true or not true to each of these conditions on his motion to revoke community supervision is the state will try to track down his original probation officer and have them testify instead of Ms. Gross reading off the document that the original probation officer forwarded to her. So that's where we're at. Whether he gets revoked or not is up to me and me alone.
No,
Judge, his officer is available at work today. We probably could get him in if the court so needs.
Okay, well, your two options, Mr. Hitchings, as you're probably already aware. Number one is you can request what I call a fully contested motion to revoke community supervision. And we'll take a break for a few minutes and Susan will track down the original probation officer to testify. And then I'll do a few other MTRs in the interim. And then when that person is available, we'll come back in and we can have your fully contested motion to revoke community supervision and Mr. Chavez can plead not true. Otherwise, if any of these are true, my understanding is, you know, he's got to truthfully plead whatever they are. They're true or they're not true, or they're true with an explanation or not true with an explanation. And we can have a normal motion to revoke community supervision, my term, that I obviously sit in judgment of without having the original probation officer come in. I'm going to hear the same information, whether it comes from the original probation officer or it comes from Ms. Gross notes that she got from the original probation officer. But y'all can certainly tell me or testify or handle it any way you want, what is true or what's not true in here, and I'll make the final determination.
Well, I think we, the district attorney's office and myself and the probation office for that matter, out of the 9 claim violations, I count 1 that he would be saying true on. And there are 2 that are true with an explanation. And the others, for example, failure to attend the DWI education program. Well, that was true at the time that it's filed, but he has completed it according to the court summary.
Okay.
Same on the victim impact panel, true at the time that it was filed, but not true. He has completed it now. Court hearing. And so I think out of the 9, there's a lot we can agree that don't really apply in the case. And
Well, how about this? How about we go step by step, one at a time, and he can plead either true or not true, and everything's going to have an explanation if it needs one. But obviously, if they've alleged that he hasn't done the DWI education program, but now he has, then it's not true. Would you agree?
that's correct as far as right now. That's incorrect as far as when it was filed.
That's when we're having the hearing is right now. So a lot of times people are able to do things in the interim between whenever the MTR was filed and they actually have the hearing. So that's where we're at on that. But if you want to do it that way, that's perfectly fine. And do that.
I think that's probably the best way to go.
All right, let's do this. For instance, there are a couple of number 14s for purposes of the record. Let's call the first number 14, 14A, and the second 14, 14B. And then we have several 20s, and the first 20 is 20A, and the second 20 is 20B, and the third 20 is 20C. Will that be okay?
That's okay with me, Your Honor.
All right, let's start with allegedly violated condition number 13, where he did not complete 48 hours of community service restitution.
Oh, Mr. Chavez, that one we talked about. Oh, you need to unmute yourself.
Okay, yes, that would be true. Yes.
Okay. And then the second one is what I'll call 14A, and it talks about between the period of time November 23rd, 2021 to the period of time December 23rd, 2021, looking like 1 month, he missed 10 blows on the Smart Start mobile device.
Your Honor, that one would be true with an explanation. The 10 skip test was when he was incarcerated on the first motion to revoke, and he was not able to do the test.
That is an excellent alibi. So let's plead not true to that one. Or actually, he did. I mean, he skipped them, but he's in jail. There's no possible way you could have blown in it. That's where we're at, right?
It's kind of a impossibility of performance.
So that you're exactly right. That one's true, but it's got an explanation. I couldn't blow in it. I didn't have the machine. I'm in jail. So that makes perfect sense. So the next one would be 14B, and that once again talks about 11 skip Smart Start mobile test.
That's right. And
between December 23rd, 2021 and January 21st, 2022. And I don't know if he was in jail during that time frame or not.
He was in jail up to the date recited on the violation report when he had his first MTR hearing on January 6, 2022, and the MTR was withdrawn. And so I am assuming that when on January 6, 2022, the MTR was withdrawn, that he was immediately released. But up until that date, he had been in jail and couldn't, no way he could do the test. And that window is covered by the time in 14B.
Susan, can you, do you have the information that would tell us the specific dates that Mr. Chavez was in jail during these timeframes? It's alleged he missed Smart Start mobile blow?
Yes, Your Honor, I will have that available for you in my synopsis. Unless you want it right now.
Well, they're in the process of pleading on all this stuff. So let's just say that.
He was booked in jail on October 1st, and he was released on October 1st. And then he was booked in jail on December 21st of 2021. And he was released from jail on January 8th of 2022.
And those are the only 2 time frames he was in jail?
Well, those are the 2 time frames that are covered in the motion, correct? November to December.
Well,
and December to January, because he hasn't been in jail since he was released January of this year.
Okay, so you would agree with the defense that he was in jail during these time frames in all probability?
No, I would disagree, Your Honor.
All right, so what dates alleged in this skips that he was not in jail? Do we know that?
Okay, back in November 23rd to December 23rd, it looks like he skipped tests on November the 13th. He was not in jail. November the 14th, he was not in jail. December the 14th, he was not in jail. December 20th, he was not in jail. He was in jail for the next set of skips. And then he started skipping again on January the 10th, as well as January the 15th. And then he went into lockout January 25th, I apologize.
And okay, and Mr. Hitchings, do you agree with the probation officer's analysis?
Well, I don't have access to the records. I think the records are going to speak for themselves. My client might have an idea on his whereabouts on those dates.
Oh, is this where I speak?
You know, I doubt any of us were going to sit down and write this stuff down and remember exactly what day we did what on blowing in a smart start machine. I mean, a hard time. We're going to have to go by the probation records if we choose to believe them.
And Judge, I'm reviewing both the actual Smart Start record and his arrest history as reported by Mocha.
All right, do that for us, and then let's go on to the rest of the allegations, and then Susan will come back and give a report. And then Mr. Hitchings, you can tell us what you think about her analysis.
Okay.
All right, so now we're down to number 15, which is did not complete the catnip outpatient drug program.
Well, that would be true, Your Honor. Now, it is pointed out in the court summary that is still pending.
Correct, meaning that he hadn't completed at the time this motion to revoke probation was filed,
right,
but he had more time to complete it. I understand. That's what you're saying, right?
Right.
Okay, so how about true with an explanation on that one? Would that work?
That would work.
And how about number 16 that talks about did not complete the DWI education program?
The court summary indicates that he completed it March 29th of 2022.
All right, how about not true to that one if he's actually done it?
Right. Well, I'm just relying on the court summary.
Well, I mean, if it says they did it, great, he gets credit. Number 17 talks about did not complete the victim impact panel.
That is true at the time, but the court summary indicates he completed it February 24th of 2022.
All right, so let's say not true to that one if he's actually done it. And then on 20, what I'll call 20A, it talks about not calling the, what does IVR stand for, Susan? Call line. I know it's your analysis testing call line, but.
Yes, Your Honor, that's the number that they call every day, Monday through Friday, which tells them whether or not they have to provide their sample for the day.
What does IVR mean?
I apologize, I do not know.
Good, I feel better now. All right, so this says that he did not call the, I'm going to call it the UA call line because that's what it really is, on January 20th, 22. And Barry, how do y'all want to plead on that one?
I'll let Mr. Chavez speak to that one. He informs me that he was never informed that he had to call that IV hotline, IVR hotline or call line. Mr. Chavez?
Yes, no, I wanted to be more, I wanted to clarify a little bit more. My probation officer told me I need to call every day. And he did tell me that if he gave me the time frames to call. And I believe he did tell me to, if I did not call, that would be considered a violation. That I was made aware of. As to me not calling, that would be under my responsibility alone because I do, there are times where I do remember I was not able to call within those hours. again, that's the call line, but I know that when I do call, it tells me if I do have to take a drug test that day or if I do not. So I was made aware of that. I was made aware. But to that I would have to say that would be true. To
All right.
not calling, yes.
What is talk about violating condition number 20A, that's January 20th, 2022. 20B would be January 14th, 2022. And C would be January 12th, 2022. Mr. Chavez, with your attorney's permission, do you agree with the probation department that it's very possible / probable that you did not call the UA lines those 3 days?
Yes, Your Honor.
You apparently called them many other days because these are the only violations alleged about that. That makes sense?
Yes, that makes sense.
All right. So Barry, you want to say true with an explanation on 20A, B, and C? Will that work?
It would, Your Honor.
All right. Susan, have you completed your search?
Yes, Judge, I pretty much gave you all the information.
Okay, so I've got confirmed skips where he's not in jail, and we don't have a reason at this time why he would skip on 11/13/22. I'm sorry, 21, 11/14/21, 12/14/21, 12/20/21, 110/22, 115/22, and went lockout on 125/22. Does that sound right?
Right. If you want me to go over every skip he's ever had back to January 24th, I would be
No,
happy to do
I
that.
think we're good. Mr. Chavez, would you agree that it's at least likely, if not probable, that their records are correct? And you have 1, 2, 3, 4, 5, 6 skips, and then I guess you didn't pay the people that went into lockout, or you had some other issue that you can tell me about. But you had 6 skips that you agree with, and then any other skips you may have been in jail or had some other valid reason for not blowing in the machine. Does that make sense?
That makes sense, yes, but I would have to disagree with the records because not that the skips were missed, yes, but I do remember being incarcerated. My probation officer at the time told me that I had an appointment with her and to go in, unbeknownst to me, that's when I was going to get arrested. But I believe I was incarcerated December. Again, I cannot remember. I know it was between December 14th and December 18th.
No, they're saying. Go ahead, sir. I'm sorry.
Oh, sorry. No, if I'm not mistaken, I was arrested December 18th.
You were arrested December 21st, and you were released on January the 8th. And any of those skip tests are not alleged in this motion.
Yeah, that I would, again, I don't mean to, with all respect, of course, but I do remember when I was in, again, I just said, I don't remember exactly, but I remember calling my family members and seeing the date. I know it was before December 20th because I called my family before then, letting them know that, hey, I'm not gonna be able to spend Christmas or New Year's with them. And that was before the 20th. Again, the records, of course, state otherwise. And again, I'm sure those records have more merit than I do at this current moment. But okay. I do remember being incarcerated before December 20th.
Mr. Hitchings, with regard to violating condition number 14A and B, which I guess is a total of 21 skips, I think Mr. Chavez has tried to be honest with us as he can be and admits to at least 6 of them being valid, but obviously none of us would have a decent memory on this stuff. The records reflect that he skipped the test. Now, whether he was in jail or not is the issue, but I think we're talking about 6 out of 21 that are probable. Does that sound equitable to the defense in our interpretation?
That sounds equitable. If the court were to look at the violation report, kind of a full picture, that indicates that he passed 381 tests. And none of those tests were positive for blood alcohol readings. And 6 tests missed and 381 completed. I think that's a pretty good batting average. It's not 100%, but it's awful close to it.
And then with regard to this representation that the machine went into lockout on January 25th, meaning it stopped working, which normally happens when a defendant doesn't pay the bill. I don't know what happened in this case. Did it ever get turned back on, I guess is my question.
I'll let Mr. Chavez respond to that. Now you're talking about the one that in lockout, the Smart Start device?
Correct. And apparently that happened on January 25th, 2022.
Okay.
Judge, do you want the rest of my background before we proceed? Now that we know what's been pled true and not true to?
Well, we don't know that yet. We're still working on that.
Okay, now I know the Smart Start, he still got at home. The Scram device was installed when he was jailed. The jail disconnected the Scram device. But in the meantime, he still had the Smart Start device at home.
Okay, so it's not, and bear with me, I have 1,500 defendants and I have a hard time keeping up with all this. But at some point during Mr. Chavez probation, we put him on a Scram Cam ankle bracelet to replace the Smart Start mobile device. That sound right?
That's correct.
Do we know what date approximately that was? Or Susan, would you have that access to that date?
Judge, he was ordered to obtain a Scram device on January the 10th, 2021. And that was as a result of a VR MTR that had been filed, but the court was gracious enough to not file the motion to revoke and instead ordered that his conditions be modified and that he be placed on a Scram device. And he signed those conditions on January 10th, 2022. And I apologize. I think I said the referral was on January 10th, 2021. It was actually on 2022.
And so what date did he actually get active on the Scram Cam device?
I don't show that he was ever actually active on the device. The last action in regards to a Scram device are the alternative conditions, which he signed on January the 10th, 2022.
Okay, and maybe you can dispel some more of my confusion at least. Did Mr. Chavez ever have a prior motion to revoke community supervision that was actually heard?
Yes.
Okay, so we had one that was actually heard and that was issued or filed on 11/23/21 and heard on January 6/22. Does that sound right?
Correct. And the court ordered that he get a Scram device within 10 days. And I do not have any record of him obtaining that device. And he does continue to remain in lockout on Smart Start as of January 25th, 2022.
And you mentioned there was another MTR that was originally filed, or maybe it wasn't filed. Maybe it was tentatively going to be filed and we just modified his bond conditions instead or his probation conditions instead. Does that sound right?
I'm looking, Judge. I may have misspoke on that. I do apologize. It was a violation report that did result in a motion and that motion was heard in January and that's when you ordered the Scram.
Okay,
Which he neglected to get. So I did speak.
Okay,
Sorry.
Mr. Chavez, at any point were you actually on the Scram ankle bracelet device?
Yes, Judge, absolutely. I let my PO everything know, and I have an extensive explanation to why I got my Scram device. It was January 25th. I did get the Scram device. I let my probation officer know, hey, I got it. Can you let the court or the people in charge know? I was on it and all the way until my incarceration this time, and I was removed here in my incarceration. And I do have receipts for that. It was $300 a month for the time I was on it. So yes, I did get the Scram device, and I remember quite vividly because it was something that I struggled to get due to my finances and my inability to work at the time. But I was able to get it, yes.
Okay, so do you recall approximately what date you actually had it active? And they may have made you put it on before you got out of jail. I don't know. Sometimes they do that.
Yes. Again, I apologize because, I don't have the records right now with me, but I
None of us
believe,
could remember all that.
yeah, so I do believe it was just January 25th, if I'm not mistaken. It
Okay,
may
and
have been earlier.
Do you remember how long you were actively on the Scram Cam ankle bracelet device?
Yes, all the way until May 5th, 2022. That was the date of my incarceration.
Okay, but Susan, your records don't show any of that. Is that what you're telling me?
That's correct, Your Honor. I have no Scram documentation
All right.
in the file at all.
I got it. Mr. Hitchings, here's what I got. For purposes of the record, my understanding is, correct me if I'm wrong, the defense is willing to enter a plea of truth and explanation to all conditions except number 16 and 17, which are not true as an explanation. Does that sound right?
That sounds correct, Your Honor.
All right. So that being said, Ms. Gross, would you please, and this gets complicated, but at your ability, a lot of us aren't really the sharpest axe in the box like me. So you could take us by the hand and lead us through this probation period and let us know what happened as briefly as possible on Mr. Chavez's probation, please.
Yes, Your Honor. Mr. Chavez has performed very poorly on probation. He did fail to report for 3 months. We have not seen him since February the 8th, 2022. He's paid $1,252 towards his fees and has a balance of $82. He has had 3 negative drug tests. He has completed DWI education, victim impact panel. We have no record of enrollment or completion of the CAPSNP program. He was on a Smart Start mobile device where he had 21 skips, and he went into lockout on January 25th, 2022 at an MTR hearing in January. The court did order that he obtain a Scram device, and this officer can find no proof that that device was ever obtained. And his prior arrest history includes an assault bodily injury, possession of marijuana 0 to 2 ounces. This is his second violation report, second MTR, and his officer is recommending that he remain on Smart Start mobile for the duration of probation within him testing 4 times per day.
Okay, Mr. Hitchings, what are you requesting?
We'd request that, like the recommendation in the court summary, that he continue on probation. He's got the Smart Start device at his home. It's just a matter of doing what's necessary to get the Smart Start device operable again. With regard to the Scram device, that was, according to what Mr. Chavez told me, when he checked himself in, that Scram device was taken by the jailer since he couldn't have Scram device inside the Bexar County Jail. So that device ought to be available somewhere. But we'd request the court continue him on probation. Money-wise, he is very close to paying off the entire amount. I think he'll be able to successfully complete the remainder of his probation. He knows he can do it. He is a very smart and intelligent young man, and we'd request the court to continue him on probation pursuant to the recommendation of the probation office in the court summary.
Susan, did you confirm that Mr. Chavez had completed the CAPSNP outpatient drug program?
Judge, we have no record of enrollment or completion of that program.
I think,
Chavez, did you do that one?
We had indicated the court summary said that is still pending. He did complete the other 2 programs. So,
Mr. Chavez, are you actively going to classes in that program at this time?
At the current moment, I am not due because I am struggling financially, but it is within my plan to complete that CAPSNP program. It is something I very dearly want to complete. And will complete given the time.
State recommendation on Mr. Chavez, please.
State recommends revocation.
And Susan, this makes crystal clear that I'm correct. This is his second actually heard MTR. Does that make sense?
Yes, Your Honor.
And do you have the original fine amount on this case?
Yes, Your Honor, it's $500.
Mr. Chavez, in clause 647640, the court accepts your plea of truth and explanation to all conditions except number 16 and 17 and not true to those because you did successfully complete those programs. I grant the state's motion to revoke your probation. I sentence you to 90 days in the Bexar County Jail. I assess a $500 fine plus court costs, credit for time served, time and money to run concurrent. Recalling all pretrial services, bond conditions, and previous warrants. Anything further from the state of the defense on Mr. Chavez?
Nothing from the state, Your Honor.
Nothing from the defense, Your Honor.
Good luck, Mr. Chavez. I could have sentenced you to 60 days, excuse me, to 6 months, but you have done some things. So thank you for that. All right. Best of luck, Mr. Chavez, and thank you, Mr. Hitchings. You are dismissed.
Thank you, Your Honor.
And what do we have next on the batting order? Ready on Ms. Torres, please. And this would be Trey Porter.
Judge, good morning, sir. We are here and we are ready. Ms. Torres is here with me.
Give me about a minute to go get the document you provided me yesterday that I have in my briefcase right here, and I'll get it and come right back.
Yes, sir. Absolutely. In ADA Read, we had provided this electronically to Eddie. He acknowledged receipt of it. I don't know if he's uploaded it to your all's files or not. I just wanted to make you aware of that.
Okay, I appreciate that. I haven't seen it, but I'll ask Eddie to forward it to me.
Yes, sir. We did confirm with him and he did confirm receipt. So I know it's there somewhere, but we can always supplement afterwards if you guys need it for the record.
Okay, thank you.
Yes, sir. You're welcome.
Arthur, if you're still listening, can you send me your email through chat, please? So I can send you a letter to review.
Okay, back on the record. Cause 634471, State of Texas versus Stephanie Torres, represented by Mr. Trey Porter. This is a motion to enter adjudication of guilt and revoke community supervision. The first document I'm looking at is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference, that is purportedly signed both by Ms. Torres and Mr. Porter. In fact, Ms. Torres, is this your signature on this document, ma'am?
Yes, sir.
Thank you. And Mr. Porter, as attorney for Ms. Torres, is this also your signature on this document?
Yes, sir, it is.
Thank you. Next document I'm looking at is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is an adjudication of guilt following a deferred adjudication and the defendant has a limited right of appeal. In fact, Ms. Torres, is this your signature on this document also, ma'am?
Yes, sir.
And Mr. Porter, as attorney for Ms. Torres, is this also your signature on this document?
Yes, sir.
This is a motion to enter adjudication of guilt and revoke community supervision. Mr. Porter, my understanding is this is going to be an uncontested motion to enter adjudication of guilt and revoke community supervision. Is that correct?
Yes, sir, that is correct.
Ms. Torres, in cause number 634471, on the motion to enter adjudication of guilt and revoke community supervision, how do you plead, ma'am?
True, Your Honor.
Thank you. Ms. Gross, would you please advise the court and the parties of the status of Ms. Torres' probation, please?
Yes, Your Honor. Ms. Torres has been reporting as directed. We last saw her on May the 11th, 2022. Her case is paid in full. She has completed all of her community service as well as DWI education, victim impact panel, and the CATSNP programs. She has had a total of 4 positive drug tests. They were positive with a prescription, and those have been confirmed that they were for a prescription drug and not a street drug. She's also had 2 positives for alcohol, which came up on the Smart Start mobile, where she's currently testing at 6 times per day. She's had 2 skips and 2 bracs. March 25th, 2022 at 0.056 at 7:06 a.m. and she did not blow to clear until 11:36 a.m. Then again on April 2nd, 2022, 0.020 at 10 p.m. and did not blow to clear until 6:55 a.m. She has no criminal history, and her officer is recommending that she go to CATS IOP and be placed on a SCRAM device for a minimum of 90 days. And this is her third, I'm sorry, this is her 3rd VR MTR, and she's been continued, obviously, prior both times.
And Mr. Porter, what are you requesting, please?
Judge, the only thing I would say to supplement what Ms. Gross said, in addition to the drug test information she gave about prescription drugs, cumulatively, Ms. Torres has successfully submitted to and passed 13 drug tests in the 8 months that she's been on probation, and she took a 14th yesterday, Judge. That's the only thing I have to add to what Ms. Gross said. Judge, you do have the packet that we provided. This is Ms. Torres's 3rd time before you on this, Judge. This is her 1st time here with me. What's different? We're not here to offer any excuses. First thing is first, Ms. Torres takes responsibility for these high bracs, and she doesn't have an excuse for it. She wants to be very clear about that, Judge. So no excuses, just solutions. Ms. Torres is a single mother. She is the sole caretaker and provider for her 3-year-old daughter, Amaris, who is in daycare as we speak right now. Ms. Torres has an excellent job with AT&T, Judge, that she's worked very hard to get and very hard to maintain. If you reference the packet, we do have a letter from a manager at AT&T here in San Antonio where Ms. Torres works, talking about her being an exemplary employee, and also mentioning, Judge, that if she were to be incarcerated for any period of time due to her missteps here, that she would be terminated from her position with AT&T. So with that being said, Judge, what we're asking for is the court to continue Ms. Torres on probation. Ms. Gross, correct me if I'm wrong, I believe you did say that the recommendation from the officer was 90 days SCRAM and CATS IOP. Is that correct?
Yes, that is correct.
Judge, I would proffer to the court that Ms. Torres has contacted Dean at CATS. She has signed up, paid, and is scheduled to start the intensive outpatient treatment program with CATS today at 7 p.m. Is that correct, 7 p.m.?
Yes.
7 p.m., Judge, and we asked the court to consider that and to allow her to do that with the screws tightened and with significantly more restrictions, Your Honor.
For purposes of the record, I'm going to have marked the mitigation packet provided by Mr. Porter for Ms. Torres as Defense Exhibit A. I commend the defense on providing a wonderful document. Doesn't get any better than this. So well done, Mr. Porter, on that one. What is the prescription drug that Ms. Torres is taking that keeps testing positive for amphetamine, I guess is what's happening?
Yes, sir. She takes two, Judge. She has a prescription for ADHD. It is a derivative of like Adderall, and that's something that will test positive. And again, Ms. Gross, please correct me if I'm wrong. We are under the impression she's provided everything needed to her officer for that. And that's why these were not listed in the MTR that we are here for today.
That is correct. Most recently, on April 13th, the defendant did provide photos of her prescription bottles for the drugs that she is taking, which are consistent with providing positive drug tests for amphetamines.
And Ms. Gross, did the probation department confirm that none of these positives for amphetamine were methamphetamine?
Not every positive test has been confirmed, but the initial one, yes.
Okay, so at least one of the positives for amphetamine was tested by the lab to confirm that it was not methamphetamine. Does that make sense?
Correct.
All right, that's all I need to know. State recommendation on Ms. Torres, please.
Yes, Judge, state's recommendation is to deny the MTR and continue on probation, amend conditions to include the Scram device for 90 days and the CATS intensive outpatient program.
Okay, thanks. So far, Ms. Torres has been on probation for 11 months. Does that sound right?
Yes, sir.
Yes, since June 10th of last year.
Okay. And what was the original fine amount, Susan, if you know?
500, Judge.
And how many community service hours originally?
36.
Mr. Porter, is Ms. Torres willing to pay the $300 a month for a Scram device for at least 90 days instead of go to jail for 6 months?
Yes, sir.
Good answer. Ms. Torres, in cause 6344471, the court accepts your plea of true on the motion to, what do we got? Motion to enter adjudication of guilt and revoke community supervision. I grant the state's motion to revoke your deferred adjudication probation. I adjudicate you guilty of the offense of driving while intoxicated, first offense. I sentence you to 6 months in the Bexar County Jail, probated for 6 months, a $500 fine plus court cost, 36 hours community service, DWI education, DWI victim impact panel, Community Alliance for Traffic Safety intensive outpatient program, weekly UAs. Mr. Porter, show me 4 clean weekly UAs. We'll put her back on monthly UAs again. Scram cam, ankle bracelet device within 10 days. Once the Scram cam is active, she can turn in her Smart Start mobile device. I'm ordering Scram cam for the duration, but Mr. Porter, I'm asking you to approach in 90 days after she's been on this thing for 3 months. If she's done well, I'm going to put her back on the Smart Start again. Okay?
Yes, sir.
I'm going to give her 30 days in the Bexar County Jail as a sanction to get her attention and make her aware of how serious this is. But I'm going to hold it in abeyance because She's the cutest little girl you ever saw right there on this little thing here. So anyway, that's the only reason she's not going to jail for 30 days.
Well, we thank you for that, Judge.
All right, let's see what else. Susan, what did I miss?
That's it, Judge. I just need to give her some instructions when you're done.
Susan, how many times have you seen me keep somebody on probation after 3 MTR?
I can probably count them on one hand over 30 years, Judge.
All right. Ms. Torres, you and Mr. Porter have a little chat when y'all go back in private here in a minute when we cut you loose. And he's going to confirm with you what a mean judge I am and how it won't bother me in the slightest to put you in jail for 6 months. Cute little girl or no cute little girl, great job or no great job. He has saved you this time. It will not happen again. So go look yourself in the mirror, convince yourself you're not going to drink anymore, and we'll all move along. Ms. Porter, do you have anything else that you would like to bring up at this time?
No, sir, not at this time, Judge.
Excellent job, defense. Good luck, Ms. Torres. Thank you, Mr. Porter.
Thank you, Judge.
All right, Ms. Porter, or I'm sorry, Mr. Porter and Ms. Torres. Pat will be emailing you some paperwork. Trey, fill it out quick. It'll go to her, fill it out quick, and then it will come back to us so that we can get her paperwork over to probation because she's got to go through orientation again. If you don't hear from probation by next Tuesday morning, by the time you wake up, get a hold of Mr. Porter and he can get a hold of me and we'll figure out what's going on, okay?
Okay.
All right, once you get active on your Scram device, let your officer know, and then they'll send a removal order for Smart Start to me. Judge will sign it, we'll send it to Smart Start, and then you can go turn in your device, okay? But in the meantime, you need to keep blowing.
Okay.
Any questions?
No, ma'am.
All right, good luck to you. Thank you, Mr. Porter.
Mr. Porter, I just sent that to you, to your office. It will go to you and then later it'll go to her.
Yes,
Thank
ma'am.
you. Ms. Porter, I have one more order for Ms. Torres, and maybe this will make it different. Ms.
Yes, sir.
Torres is ordered to keep a picture of her child with her 24 hours a day. And the next time she gets motivated to drink alcohol, she's going to look at that picture before she does anything. Is that okay with you, Ms. Torres?
Yes, sir.
All right. Take care of your child. Thank you, ma'am.
Judge, thank you, sir. Maybe we be excused.
Yes, sir. Thank you.
Thank you, Judge.
Okay, we ready on Jacob Juarez? Sally, you with us?
Yes, Judge, I'm here.
Let's see. This is cause number 655767, State of Texas versus Jacob Juarez. This is a motion to revoke community supervision. Ms. Juarez is representative of Ms. Sally Gonzalez, and the first document I have to look at on this case is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference, which purports to have signatures both of Mr. Juarez and Ms. Gonzalez. In fact, Mr. Juarez, is this your signature on this document, sir?
Yes, Your Honor.
Thank you. And Ms. Gonzalez, as attorney for Mr. Juarez, is this also your signature on this document?
Your Honor, I was here on his first MTR and I can't see what can you share the document with me?
This document we're looking at, or I'm looking at, is the defendant's consent to motion to revoke hearing by video conference. And you may have.
Oh, I'm sorry, Judge.
May 20th, this one is
Yes.
dated. So you did it earlier. So thank you for doing that. So I
Yes,
assume this
that's
is your
my-
signature.
Yes, it's my signature.
All right, wonderful, thanks. The next document I have, Mr. Juarez, is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction. In fact, Mr. Juarez, is this your signature on this document also, sir?
Yes, it is, Your Honor.
Thank you. And Ms. Gonzalez, as attorney for Mr. Juarez, is this also your signature on this document?
Yes, Judge.
Okay, this is a motion to revoke community supervision, cause number 655767. My understanding, Ms. Gonzalez, is this is going to be an uncontested motion to revoke community supervision. Is that correct?
I believe he's going to plead true with explanation.
Fair enough.
3 counts of violations.
Mr. Juarez, in cause number 655767 on the motion to revoke community supervision, how do you plead, sir?
True with explanation, sir.
Thank you, sir. Ms. Gross, would you please advise the court and the parties of the status of Mr. Juarez's probation? I remind you, you're still under oath.
Yes, Your Honor. Mr. Juarez was reporting as directed up until March 11th, 2022, which is the last time we saw him. He did not report for his last month of probation. He has paid $1,224 towards his fees. He has a, hang on here. I wrote something down incorrectly in regards to his fees. Must have been dyslexia for the day. In regards to his fees, he has paid a total of $1,224, and he has got a balance of $507, currently delinquent $538. He was on Smart Start Mobile where he successfully completed that term, and it was removed on February the 9th, 2022. He has had 9 negative drug tests. He's had 3 positives for alcohol, which occurred February 22nd to March the 8th. He's completed DWI education, victim impact panel, CATS IOP, CATS NIP, and on November 22nd, 2021, the court placed him on weekly drug testing, and the defendant did not follow through with this. His prior arrest history includes an unlawful carrying of a weapon, and the case did expire April 26, 2022, and his officer is recommending that his probation be terminated unsatisfactory. This is his second violation report. First, motion to revoke.
Did he not go through a motion to revoke probation where I took away his deferred adjudication before at some point?
Judge, in regards to his hearing and MTR history, he did have an MTR that was filed back in November of 2021. That MTR was heard November 22nd, 2021. And the only thing that you did at that time, excuse me, was that you altered and amended those conditions to add weekly drug testing within 24 hours. And the defendant did not follow through with that.
Okay, but at the original MTR hearing, I guess the first MTR hearing, I revoked his deferred adjudication and put him on regular probation. Does that sound right?
No, he's still on deferred, Your Honor.
Okay, so why does the document I'm looking at, which is the motion to revoke community supervision, not say motion to enter adjudication of guilt and revoke community supervision?
That's a very good question. Let me review his original documents, Your Honor.
Susan, the system, MOCA has him on regular.
Yes, it is correct, Your Honor. He was on deferred, and you did reform his judgment October 27th of 2021. And then he has had subsequent MTRs, and that's when you ordered the weekly UAs, and he failed to comply with that.
All right, so there's been one prior motion to enter adjudication of guilt and revoke community supervision, and that's the only other MTR that's been heard on this case until today. Does that sound right?
Judge, he had a MTR that was filed July 22nd, 2021. It was heard July 26, 2021, and you amended his conditions. There was a second MTR filed on the deferred case on September 27th, 2021, and that MTR was heard on September 30th, 2021. That's when you reformed the judgment, you put him on regular. Then there was a violation report that was filed in November of 2021, and the MTR was not filed. You gave him the opportunity, and you ordered weekly drug testing, and he did not comply with that, which is why this MTR has been filed to allege his non-compliance with those orders.
So technically, this is Mr. Juarez's third motion to revoke probation. Does that sound right?
This is his third appearance before you for violations. Yes,
I
Your
got
Honor.
you. All right. And apparently, the first time we had an MTR, I did not revoke his deferred adjudication. Does that sound right?
That's correct. You merely amended his conditions.
I got it. Okay, Ms. Gonzalez, what are you requesting?
Well, Judge, I've been on this case since the second MTR. I guess it was in November. I can't remember. Is that true, Susan? It was in November, the second MTR?
The second MTR, the date on that one, when it was actually heard, was October 27th.
Okay. And so, so I really can only speak of since then. And that was, there were some discrepancies in the report. So you did give him a chance to just continue on his probation at that point. He does have the 3 violations that we're in court on today that were, so his probation was going to end in April 26th, I believe. And it was in February that I believe he had 1 violation at the end of February for testing positive for alcohol, and then 2 at the beginning of March. So I believe in a 3-week period came about these 3 violations, which are all alcohol related. I guess I just really want the court to take into consideration how well he has done. All that he's a 19-year-old kid. He has completed his classes. I'd like for you to pay attention to how much, how hard it is for a kid his age to pay the all the fees that were assessed for him. It has come to my attention earlier today that he does have a baby on the way. The baby will be here in November. The important things to this defendant is just to stay out of jail and being able to continue working where he has secured a new job. He's no longer working at a bar. He's working for a construction company. We did send you a letter and forwarded it to the ADA for your review. He's doing really well at his job, doesn't want to lose his job. And Mr. Juarez was also like to speak to the court. You do have my permission to speak to him directly if the court so chooses.
Great. Hey, Mr. Juarez, I can't stop you from drinking. That's my elephant in the room. What's going on?
Well, Your Honor, I'm gonna not beat around the bush. With knowledge of almost being completed with probation, I slacked a little bit. I was tested by God with temptation and I failed. Not only did I fail his test, I failed myself and everyone that I know. And I gave in and I drank a little alcohol every now and then, and I failed on 3 counts of UA test. I have not been happy with myself about it because I know I'm better than that and I can do better than that. I've been doing better than that. So for me to mess up so closely at the end of my probation sentence, it really has been eating me alive. And I do take full responsibility of my actions, but I also regret them very much. Like my attorney stated, I am going to be a father soon, and me going through all of this court stuff is something that I need to get past, and it's something that I don't need to be doing. I need to be a father, and I need to mature, and I need to move on and better my life, not only for myself, but for my soon-to-be family. I need to be there for them, and I need to support them at all costs.
And I'm trying to pull up your letter that y'all sent me. I haven't had a chance to read it yet, and I want to read it real quick.
Yes, I had made my superintendent aware of me not coming into work today because I was also under the impression it was going to be in person. I had went to the courtroom this morning at 8:30, and then I was sent an email with the Zoom code and whatnot. So I had told him I wasn't going to be coming to work 2 weeks prior, and he went out of his way and felt the need to write a letter of recommendation for me because I have been doing so well that he hopes that you can understand that I'm only maturing and I'm only growing up, and I made a mistake, and I take full responsibility for that mistake, but I am also learning from that mistake. And he felt that he also needed to say something on his behalf because I have been doing very well at work and whatnot, and doing my best to better my life.
When is your trial due, sir?
When is my trial due?
Yep, no, not trial, child. Aren't you having a child?
Oh, yes, no, she's expected to be here November 15th.
Okay, congratulations.
Thank you, Your Honor.
Susan, let me confirm for me what specific programs Mr. Juarez has completed on this probation.
Judge, he's done well with his programs. He completed DWI education, victim impact panel, CATS NIP, and CATS IOP, as well as his 24 hours of community service.
None of my outpatient drug programs are working. State recommendation, please.
Your Honor, state recommends the Scram Cam device, weekly UAs, and continue him on probation.
When does he technically come off of probation, Susan, or is he already termed out?
He expired last month on April 26th.
Okay. So we do not have the ability to extend him. We're done. Is that not accurate? If he was still on deferred, I would be able to start him over, but I don't have that option now. Is that correct?
No, you can extend him, Judge.
Oh, I still can. Can I extend him about 5 years? I think that's what it's going to take to get him to finally get it figured out.
No, nice try.
Mr. Juarez, you willing to go on a scram bracelet for $300 a month?
Your Honor, whatever it takes for me to still be able to go to work and support my family.
Hey, if I don't revoke Mr. Juarez after his third MTR and put him in jail for 6 months, are you going to make fun of me in the future and tell stories about me?
No, Your Honor.
All right. Mr. Juarez, the call 655-767. The court accepts your plea of true. On the motion to revoke community supervision, I deny the state's motion to revoke your community supervision. Order you continued on community supervision, altering and amending, extending you for 6 months, ordering the scram cam within 10 days. Did we put him back on a smart start after we had these violations, or we haven't really had time to do that yet?
No, he did not have a smart start. He was off as of
Okay.
February 9, 2022.
And add weekly UAs. If he shows me 4 clean weekly UAs in a row, we'll put him back on monthly UAs. And is there anything else he needs to do, Susan, other than stop drinking?
No, and just for the record, because the extension goes to the date when he expired, he'll basically have 5 more months of supervision.
That's okay. That sounds about right. All right.
And
Mr.
is he
Al-
gonna be on scram for the duration?
Yeah. I think that would be adequate punishment. Ms. Gonzalez, you agree with this decision?
Yes, Judge, thank you.
Have you advised your client how close he's come to going to jail for 6 months?
Judge, I thought
Well,
that's where he was going today.
Mr. Juarez, you got anything further to say? Your attorney has saved you. This will be the last time that's going to happen.
Yes, Your Honor. It'll also be the last time I will be here because I've learned my lesson. It doesn't take much for me to get the point to grow up, you know, especially when I have a daughter on the way. That's
all right. Well, you've done well on the work thing, switching from being a bartender to being in construction and having a boss that's willing to write that nice a letter for you. Somebody likes you.
Yes, Your Honor. Thank you.
All right. Anything further from the state or the defense on Mr. Juarez?
Nothing from the state, Your Honor.
Good luck, Mr. Juarez. Thank you, Ms. Gonzalez. You are dismissed.
Thank you, Your Honor.
Juarez, you will receive an email from me later this afternoon with your amended conditions, okay? It'll come to your email. Watch for it, sign it immediately, and send it back to me, okay?
Yes, ma'am.
And then touch base with Mr. Hinojosa and let him know that you were in court today and that you were continued with an extension. And he can probably get that referral over there so that they can get that started in case there's a waiting list, okay?
Yes, ma'am.
All right, good luck to you, sir.
Thank you.
Thank you, Susan.
Okay, Mr. De La Paz, are you still with us?
I am, Judge.
All right, let's try to get these guys squared away. This is cause number 604838, State of Texas versus Rudy Castillo. This is a motion to revoke community supervision. Representing Mr. Castillo is Mr. Brent De La Paz. The first document I have on this case is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference that purports to have both Mr. Castillo and Mr. De La Paz signatures on it. In fact, Mr. Castillo, is this your signature on this document, sir? Oh, your microphone is turned off, sir. There you go.
Yes, Your Honor, it is my signature.
Thank you. Mr. De La Paz, as attorney for Mr. Castillo, is this also your signature on this document?
It is, Your Honor.
Thank you. The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction. In fact, Mr. Castillo, is this your signature on this document also, sir?
Yes, Your Honor, it is.
And Mr. De La Paz, as attorney for Mr. Castillo, is this also your signature on this document?
It is, Your Honor.
Mr. De La Paz, my understanding is that this is going to be an uncontested motion to revoke community supervision. Is that correct?
It is, Your Honor, with explanation.
Thank you. Mr. Castillo, on cause 604838 on the motion to revoke community supervision, how do you plead, sir?
True, Your Honor.
Thank you. Ms. Gross, would you please advise the court and the parties of the status of Mr. Castillo's probation? I remind you, you're still under oath.
Yes, Your Honor. The defendant has been reporting as directed. We last saw Mr. Castillo April 21st, 2022. He's paid $694 towards his fees, has a balance of $4,555.18. He's current on his fees at this time. His 48 hours of community service were probated. He's completed DWI education, victim impact panel. However, we have no proof of enrollment or completion of the CAP-SNP program. He has had one negative drug test. He's currently on Smart Start Mobile, where he's testing 4 times a day. He's had 3 skips as alleged on the motion and 4 additional skips since the motion was filed, and is currently in lockout. He's had 1 negative drug test. His prior criminal arrest history includes 2 arrests for criminal mischief, 1 for $750 to $2,500 and 1 for $2,500 to $30,000. His officer is requesting that his conditions be amended to reflect that he be active on all of his programs within a total of 10 days.
Okay, and he's done. What did you tell me? DWI ed and the victim impact panel, but we don't have any information on CAT-SNP. Does that sound right?
That's correct. He's only been on probation since March 17th.
Okay, so April, May, 2 months maybe, plus or minus.
Correct.
Mr. De La Paz, the elephant in the room is the issue of this lockout thing. Are we still on lockout, or we got that fixed yet?
Your Honor, I thought it was fixed. The initial lockout was due to non-payment, which should correspond, last I checked, with the dates that he initially missed. He subsequently got all his payments in order. I don't know of any missed tests in the recent, or I wasn't advised as to any recent tests. And he also is enrolled in CATSNP. He has not completed it. I think he's only gone through one or two so far. But
hey, Mr. Castillo, how many classes at CATSNP have you attended?
I've attended one CATSNP class, sir.
All right, like last week probably, or when it was that?
Yes, sir, last week.
And then are you currently, is your Smart Start mobile device working today?
Yes, sir. It is. It's so since the lockout, I couldn't get it done right away because they were closed. I called immediately prior to the next test that was due. I wasn't able to get it unlocked. I blew, but it wasn't accepting it. I called my probation officer immediately, and he said, okay, we'll call him. We'll see if we can't, then go first thing in the morning and try to get it squared away. So as soon as they were open, I was able to get it unlocked, and I began immediately blowing again. So the only tests that I had missed were because it was locked out. But I did notify my officer right away and try to get it reinstated immediately. But unfortunately, it wasn't. There was a couple of windows, 2 or 3 maybe, that I had to miss because there was no way to get it unlocked at that point.
Okay, and why did the machine go into lockout in the first place? Do we know?
Yes, payment. My payment was a few hours late, and once there was no way to get that redone.
And
it was a Sunday, I believe, or no, I'm sorry. Yes, sometime on the weekend.
Are you still employed by Lone Star Ambulance?
Yes, sir, I am.
Are you a paramedic, or what is your status?
I'm currently the director of operations with Lone Star Ambulance.
Okay, I got you. Okay, Mr. Del Paz, what are you requesting?
In discussion with the state, at least my request, and at least from their standpoint, I think it was a reasonable request, was to continue him on. I believe probation pointed out he's only been on for 2 months, and if not, but for that lockout, I don't even think we're here in front of Your Honor. I think his either your last chat with him during the plea, or his prior military has kicked in, and he got on the ball to get a lot of things done in a very short amount of time.
I missed this, Mr. Garcia. How long were you in lockout? Days, weeks, months? How long?
It was just the rest of that day till the next morning when I could get it unlocked.
So like, well, it wasn't 24 to 48 hours is all you were in lockout, something like that?
Less than 24 hours, sir.
Okay, and what'd you do in the military, sir?
I was a field radio operator with a 4th Recon unit here in San Antonio.
Did you go to the war?
I did, sir.
Iraq, Afghanistan, both?
Iraq.
What year were you in Iraq?
Oh, 2006, 2007.
How was that?
It was rough, sir.
Okay, well, thanks for your service, sir. Okay, state, I got it. What's your recommendation?
Your Honor, the state's recommendation is to deny the MTR and continue him, and probation's recommendation to enroll in all programs and be active within 10 days.
So Susan, as we speak, my understanding is everything's working. The Smart Start Mobile is working at 4 blows a day, and he's actively starting to pursue some of these programs, and he's got CATSNP going. Do you agree?
Yes, Your Honor.
Mr. Castillo, on cause 604838, the court accepts your plea of true with an explanation. I deny the state's motion to revoke your community supervision, or you continued on community supervision with no sanction at this time. Although I have the authority to put you in jail for 30 days to get your attention. Will that be necessary, sir?
No, sir.
Good answer, sir.
Thank you.
And you had me in suspense there for a minute. And requiring substantial compliance in all areas, meaning within 10 days, I want you to be registered for any programs that you're not already registered for. You already got CATSNP and DWI Ed and Victim Impact Panel, I think. So, Susan, what else does he need to register for?
That's it. I believe he said he's already enrolled in CATSNP, and he's completed one. So as of this moment, Your Honor, he is in full compliance.
Whole lot better than his lawyer could do under the same circumstances, I'm here to tell you.
I think that's right, Judge. I think that's pretty accurate.
All right. Thank you, Mr. Castillo. Good luck to you. Thank you, Mr. De La Paz. Y'all are out of here.
Mr. Castillo, Because the judge did not make any changes to your conditions of probation, you will not be receiving any paperwork from me. You're going to continue on as normal. So give Mr. Fonseca a telephone call, let him know that you were in court this morning and that you were continued and no changes were made, and I will update your file probably later this evening. Okay, do you have any questions?
No, ma'am. Thank you. Thank
All
you.
right.
Appreciate
Your
it.
Honor,
Thank you,
Mr.
Honor.
Stevenson has come back in.
He already got the big deal today. Now what do you want?
I am as aggravating as the mange and twice as hard to get rid of, Your Honor.
Like roaches. You're like roaches. You won't
I
leave.
scurry. I scurry. Okay.
What you got, Ben?
15 days ago, I filed a motion. I have a client who has a criminal mischief, Class B misdemeanor, but because he caught a new felony while he was on bond, he ended up getting GPS full house arrest. He has been on that GPS full house arrest for, I believe we said it was more than, goodness, it's been 16, it's been since March 23rd, Your Honor. He's been on GPS full house arrest for over 2 months. His pretrial services officer wants him working. He wants to work. His dad wants him to work. He has a job to go to.
You see this file of documents?
I just sent it to Pat.
Oh, but do you see my pile of documents I'm holding?
It's big, Your Honor.
That's all the pending motions to modify bond conditions we have on our 1,500 defendant. Let me find yours while I got you here. So tell me your client's name, please.
Eddie Gonzalez with a Z at the end. And I have I just emailed the motion and order to Pat this morning.
I will send it to you, Your Honor, if you just give me a minute to find it. Okay, Your Honor, I'm going to forward it to you
Okay.
right now. Your Honor, can we go off YouTube or do we need to stay?
No, we can go